When a new EU regulation comes out, no one really understands what it means, what we have to do. It's always so complex, and some people don't even know that some regulations are actually being implemented. Let's change that. Hi beautiful people, my name is Jimmy from the Webonaut. I hope you're doing good. Welcome back to the channel. In today's video, I invited Robert Babich, legal consultant, to help us understand what this new EU regulation called right of withdrawal actually means for us and what has to be done to comply completely so you don't get in trouble. So, let's roll the tape. More or less a week ago, I came across a post from Eduardo Guzzi on Facebook mentioning a new EU regulation that would be taking effect on the 19th of June 2026. I was personally not aware about it, but since I live under a rock, I thought it was just normal. But it appeared to be that I wasn't the only one. So before we talk to Robert, legal consultant at chiroptera.com, Eduardo Guzzi and his work partner Matteo Alfieri created a free plugin to be compliant with this new EU directive. And to be honest, it's so awesome to see people putting these kind of things together to help the community. So Eduardo and Matteo, thank you very much. On another note, if you're using Fluent Cards, this regulation has already been implemented directly in the plugin. And this, my friend, shows the dedication of Jewel and his team at WP Managed Ninja. Kudos to them. But enough talking for now, let's demystify it all. Oh yeah, just a little disclaimer right before, this video is purely for informational purposes and is not legal advice. If you're looking for tailored guidance, reach out to an expert like Robert or any other qualified professional. Second disclaimer, I'm not affiliated to Robert's business, chiroptera.com. Any links to their business are just for you to find them easily. Let's get into the video. So, hi Robert. Thank you very much for thank you very much for accepting this interview. I think it's going to bring a lot of information to the community. It's a very important rule that we're going to be talking about. But before, I would like to ask you a little bit about you. Can you tell us who you are, what you're doing, so the people that are watching our video can understand where you're from and what you're doing?
Yeah, thank you for the introduction, Jimmy, and thank you for having me. In short, my name is Robert. I have a master's degree in law from the University of Ljubljana. I'm also a licensed tax advisor, registered trademark and design representative, and a legal consultant and founder of Chiroptera Consulting, which is a legal office based right here in Slovenia. We work day in, day out with e-commerce founders, with SaaS businesses who are implementing AI, who work with consumers, and so we know the law in and out.
Nice. Well, so today we are going to be talking about a rule that just came out and it's actually coming into effect actually today. We're going to be talking about the right of withdrawal, which is a rule that just came out, or at least it came out, if I'm correct me if I'm wrong, but it came out quite a while ago, but because of the new technology, it had to be updated to our technology. And it's the right of withdrawal. So that means that now we have to have a specific button on a website or e-commerce site, basically, in order to be able to give the right of withdrawal for any customers that purchase something on our websites. So for people that never has heard about it, what is the main goal of this law exactly?
Thank you for this introduction. Yes, you are correct. So the right of withdrawal was informed with the Consumers' Rights Directive, which came out a while ago. So the first thing we got to discuss, we said, yes, it comes into force today. But the first thing we need to talk about is the EU law. So EU law, obligatory law, comes in two main flavors. One is regulation and the other is directive. So a regulation is directly applicable. That means, if it were a regulation and it would say, it comes in effect on 19th of June, that means it would come in effect that day in all member states. But since this is a directive, it's not directly applicable. It needs to be transposed into local laws. So member states need to transpose this rule into their own law in order for it to apply. There are certain exceptions, and yes, member states had until today to transpose this, but many of them have not yet done that. So it's not like tomorrow the local enforcement is knocking on the door. But yeah, of course, some member states have already implemented this, and for those you need to be ready. Either way, it's a good thing that that e-commerce platforms plan ahead, that they implement this early so that they don't get struck with unnecessary fines. So yeah, as I said, directive, you label it correctly. That the withdrawal right as itself was here a long time ago. But yeah, if for me to answer the question straightforward, the main goal of this law is that it makes leaving a contract as easy as entering one. So buying online usually takes just a few clicks, but canceling often meant like hunting for a buried email or form within 30 pages of terms that,
Right.
hyperlinks to three other terms and conditions and stuff like that. So yeah, from the 19th of June, traders must provide a clearly labeled, easy to find withdrawal function so consumers can exercise the right of withdrawal in 40 days cooling off period without any obstacles. So we'll talk later about, the 1, 2 steps and stuff like that. So yeah.
So, well, I've seen in the post mainly that I discovered that law, because for me as well it was completely new, that there is a lot of confusion online because of the name of this law basically, and that's the Directive 2023/2673, if I'm correct, and and it explicitly says it's about financial services. So why are you warning regular online stores selling everyday items like clothes, gadgets, or subscription that they are trapped by it too as well?
Here is a common misconceptions. Yes, the directive is the Financial Services Directive, and it replaces the old Financial Services Directive, the Distance Financial Services, of course. So why regular shops are caught despite the financial services name? The directive is mostly about distance financial services, but it also inserted a brand new Article 11A into the General Consumer Rights Directive. That button rule applies to all online consumer contracts where a statutory right of withdrawal exists, not just financial services. So clothes, gadgets, and most subscriptions are squarely in scope.
Okay, but what then if an e-commerce business is physically based outside of Europe, like the US, the UK, or Canada, but they ship to European customer or target them with online ads? Do they still legally have to build this button into their website as well?
In short, yes. If they sell to or target EU consumers, the obligation isn't limited to EU established traders. It applies to any trader offering goods or services to consumers through
Okay.
online interfaces where a withdrawal right exists. Targeting the EU typically means shipping there, running an EU language site, or pricing in euros. So a US store that lets EU customers buy and receive goods is in scope regardless of where it's registered.
Okay, so what would actually happen to an online store if that decides to just ignore this rule? Beyond the government fines, can their payment processor like Stripe, PayPal, or Shopify step in and shut their account down?
That's a great question. So, government penalties are the legal risk, which will be discussed later. Separately, processors like Stripe, PayPal, and platforms like Shopify aren't enforcing this law, but their own terms require legal compliance. And a missing or clunky withdrawal flow tends to drive complaints and chargebacks. High
Okay.
chargeback ratios and unresolved disputes can trigger account reviews, holds, or suspensions under their policies. So it's not a legal sanction, but it's a real commercial risk.
Now, I'm actually curious on how this cancellation button is actually going to work. So, how strict is the EU about where this button actually goes? Can a store owner just bury a text link inside a massive terms and condition page, or what are the exact visual placement required to be fully safe, actually?
So yeah, they're quite strict about both the placement and the wording. Um, to put it simply, a buried link inside terms is not enough. The function must be available throughout the withdrawal period, prominently displayed and easily accessible. A
Okay.
non-binding recital suggests using hyperlinks leading to the function and says a logged-in consumer shouldn't have to re-enter login or contract details. In practice, a visible footer link plus a dedicated withdrawal page is the safe pattern. A plain text link can suffice. It doesn't strictly have to be an HTML button.
Okay, but the law says this must be simple and standardized with a two-step process. Can you walk us through exactly what happened when a customer clicked the button? What are the basic info that are allowed to ask for in step one, and what are you legally forbidden for making mandatory?
The two-step process, step one lets the consumer send a withdrawal statement and provide or confirm just three things: their name, details identifying the contract, and the electronic contact details to receive the acknowledgement. You may not make withdrawal conditional on extra hoops, extra data, no forced account login, no app download, no requiring a reason, no mandatory phone call. Then comes the confirmation step. So clicking just, I confirm that I want to withdraw.
Yeah, I've read the law, but I mean, obviously for me it's super complicated. But I've seen that the EU is very, I've seen that the EU is very picky about the exact words used for that button. Is the exact phrase a store owner needs to put on the initial buttons, and what exact text is required on the final two-step button to prevent accidental misclicks?
The E is very strict. It gives an exact label, but it's also open while using the or an unambiguous equivalent. So the first control is labeled, the button that must be visible at all times is labeled withdraw from contract here, or an
Okay.
unambiguous equivalent. After a consumer enters their details, a confirmation control labeled confirm withdrawal or an unambiguous equivalent is provided. So specifically designed to prevent accidental withdrawals. So avoid words like cancel, which are legally a different act. Cancel is used in a sense, ending an ongoing subscription going forward, not the cooling off right of withdrawing from the contract.
Yeah, and I saw as well that a lot of online shops makes you log in into a customer account to start a return, but this law says you can force people to log in or download an app, especially if they use a guest checkout. How are websites supposed to handle guest withdrawal safely without risking data leaks?
Yes, you're correct. You can't force guest buyers to create an account or log in. But what sellers should do is build systems where they have unique identification numbers for each orders.
Okay.
So the consumer must provide this identification number, their name, and their email. But the email doesn't have to be the same as the one provided at the purchase. So it's basically the order is identified by the number itself. The name is there as a secondary control. That actually ties into the GDPR's one of its core principle, the data minimization principle. With that, you're not using a bunch of personal data. It's just two pieces of data. One is a unique identification number and the other is the name. So the email is mostly used to send the acknowledgement. So the file, which basically acknowledges that the consumer has successfully withdrawn from the contract, which needs to be provided on a durable medium, which we'll discuss later, of course. So yeah, send the acknowledgement to the email on file and update the privacy notice, since attributing a withdrawal to a consumer means processing contract and customer data in a GDPR compliant way. So you must do the update with the button as well as update your privacy stuff. So the privacy notice, the privacy policy, and your data flows are all compliant with GDPR as well as this new amendment of the CRD.
Yeah, I mean, we know that European regulators absolutely hate dark patterns. The sneaky website designs that prevent people from leaving. Once this law starts, will it completely be illegal to show discounts pop up or screen asking, "Are you sure?" To stop someone from hitting that button?
So the single confirm withdrawal step is not only allowed, it's required. It exists to prevent misclicks. What's not allowed is extra friction layered on to stop people. Retention discount pop-ups, repeated guilt screen, you lose your benefits, and or anything that makes living harder than buying. So the governing principle is that withdrawing online should not be more burdensome than concluding the contract online. One clean confirmation is fine. A retention gauntlet is not fine.
So the moment a customer clicks that final confirmation button, what two automated thing must the website do immediately to give the customer a legal receipt?
On confirmation, the trader must send the consumer an acknowledgement of receipt on a durable medium without undue delay, including the content of the withdrawal statement and the date and time it was submitted. In plain terms, the first thing, immediately record timestamp the submission, and second, send a durable confirmation via email, ideally with a PDF, capturing what was withdrawn and exactly when. This is way better than hyperlinks because links can change, but PDF is a durable medium.
Now let's talk a bit about the scope, the exemption, and the fine print, basically. We know that some items are completely exempted from the standard 14-day return rule under the EU law anyway, like custom-made t-shirt, fresh food, or unsealed hygiene items like cosmetic or underwears. If a website only sells those exempt things, do they still need to build and show a withdrawal button?
So yeah, contracts with no statutory withdrawal rights, as you said, bespoke goods, perishables, sealed hygiene products, once unsealed, are not subject to the button requirement. So a store whose entire catalog is genuinely exempt doesn't need one. The catch is that most shops sell a mix, so the button is required for the in-scope items and the owner must correctly map which is which.
And what about digital products like ebooks or software downloads? Do they need to have a cancellation button, or can a store legally skip it by having the user check an agreement box at checkout?
There is an exemption exactly for those products, so you can remove the withdrawal right for digital downloads, but only if the customer gives prior consent, acknowledges they lose the right, and you confirm this on a durable medium. So all three must be met before access begins. So a generic I accept the terms box is not enough. It must be a specific informed step. Done correctly for those items, no withdrawal right means no button for them, but you still need the button for everything else.
So we just covered the B2C part, but does this new rule apply to business stores, or is it strictly for retail consumers? I'm wondering what unique precautions should a mixed storefront take if they sell both companies and regular people on the same site, sorry.
No worries. Okay, so the right to withdrawal protects consumers, people buying outside their trade or business. So a pure B2B sale don't need the button. A mixed store must reliably separate business buyers from consumers. Where you genuinely can't tell, treat the buyer as a consumer to stay safe. Be aware that someone buying partly for personal use may still count as a consumer.
And what about charities or nonprofits selling membership or event tickets online? Do they need this button, or do the law give them a pass?
So yeah, for charities and nonprofits, there's no blanket pass. It depends on what they sell and whether they're acting as a trader toward consumers. Importantly, contracts with no withdrawal right are out of scope. So event tickets tied to a specific date generally fall under a separate exemption for leisure services, so they typically don't carry a withdrawal right anyway. Pure donations aren't sale or service contracts in the usual sense. Paid memberships, by contrast, may carry a withdrawal right unless an exemption is applied.
Just we are clear on the law, what is the actual technical difference between a customer withdrawing from a contract using this button and just doing a normal product return, actually?
A withdrawal is the EU's statutory cooling off right. 14 days no reason needed, the contract is unwound, and you refund the price plus standard delivery. A return, on the other hand, in everyday use is usually the shop's own voluntary policy, say a 13-day returns or store credit, which is contractual and can be more generous, or it's a faulty good claim, which runs on different law. The button is only for the statutory withdrawal, not for voluntary returns or warranty claims.
So there is something that worries me about with this law, because we can obviously abuse this law, or at least I can imagine that people will try to abuse this law. So once a customer clicks that button, a strict 14-day refund clock starts ticking. Does the store owner have to send the cash back right away, or is there a cash flow shield that lets them wait until they actually get the physical product back in their mail?
You must refund within 14 days of being notified, covering the full price, including standard delivery, but you can withhold the refund until you receive the goods back or the customer provides proof of return shipment, whichever comes first. That shield doesn't apply though if you offer to collect the goods yourself.
Okay, and when processing a refund, does the store have to return the initial shipping fee the customer paid at checkout, or what if the customer willingly paid extra for overnight express shipping?
This is one of the things most e-commerce shops get wrong. You must refund only the standard, so the cheapest delivery. You don't have to refund the extra a customer chose to pay for a premium option above your cheapest standard delivery. So the express premium can be excluded.
Okay, and who legally pays for the shipping label to send the item back to the warehouse? Is it the customer or the store? And what must be written in the store policy ahead of time to protect the business from getting stuck with the bill?
The customer bears the direct cost of returning the goods, but only if you told them so before purchase. Not only in your terms, but in your pre-contractual information. If you didn't disclose it, you're stuck with the bill. So state it clearly at checkout and in the withdrawal policy. So it can't just be buried somewhere in the terms and conditions, but it must also be a part of the pre-contractual information, which is built out into your checkout flow.
This next question is something that I really wondered. And what stops a customer from ordering an expensive outfit, for example, wearing it to a party and then using this effortless new button to get the full refund? Can a store owner deduct money from the refund under the diminished value rule, or if the item comes back heavily used or damaged?
Customers may handle goods to check their nature, characteristics, and functioning, like trying clothes on in a shop. For handling beyond that, wearing it out, damaging it, washing it, you may reduce the refund for the loss in value, but only if you properly informed the customer of the withdrawal right. If you didn't, you can't deduct. Note that you cannot charge a restocking or penalty fee for exercising withdrawal. A diminished value deduction is not the same as a penalty.
Okay. And since the burden of proof sits entirely on the business owner to prove an item was abused, what practical ways can they do that? Do they do things like high visibility security tags, or filming the unboxing process actually holds up legally if a customer fights the charge with their bank?
Practically, photograph condition at dispatch and on return. Use tamper evident or hygiene seals and document your condition checks. An unboxing video can help but isn't a magic shield. So use credible evidence is what counts. And customers' bank chargeback is a separate process that runs on credit card schemes' own rules. So good records help, but don't automatically win it. Another note I must add here is that this is something that kind of differs from member state to member states, which is frustrating. For example, in Slovenia, we had cases where the authorities actually took a stance that even if the good is damaged, you must still refund the full price first and then demand it back as as the damages they did. This, in my opinion, in my humble opinion, is a bit excessive. So I think this will when the time passes, it will become more balanced, but that's something to watch out for because local supervisory authorities sometimes um, have really creative ways
Yeah.
of reading and interpreting the law.
Yeah, yeah, indeed. Well, we went over a lot of points about that rules. Let's talk now a bit about penalties and what's the next step. I heard a crazy rumor that if a business forgets to add this button, their standard 14-day return window automatically gets extended to a whole year. Is that actually true? And how does that penalty work?
Okay, so yeah, that is the clickbait title that most articles use. It's partially true, partially overstated. The law even before this edition stated that if you do not inform the consumer before the purchase is completed about the withdrawal period. That period can be extended by up to 12 months. So it
Okay.
basically becomes 12 months plus 14 days instead of just 14 days. So that is tied to failing to inform the consumer of the withdrawal right. But is informing them but forgetting the button the same as not informing them at all? This is where the answer is not so one-sided because if you inform them correctly but just forgot the button, that doesn't automatically mean that you forgot to inform them at all. But again, that might depend on member state to member state. So just to be on the safe side, do both. Pre-contractual information is key to your e-commerce success, and this button is the other part of this enforcement.
Aside from giving customer a whole year to return its item, what kind of cash fines can government slap on businesses that miss this deadline?
Uh, these are set by national laws and vary by country, so vary by member state, as I said, because the law is being transposed into national laws.
Mhm.
The EU benchmark for widespread cross-border breaches is a maximum fine of at least 4% of annual turnover or up to 2 million euros,
Whoa.
where turnover can't be determined, on
Yep.
top of injunctions and cease and desist orders. The 10 million euro figure circulating online isn't the right reference for this directive. Also relevant, on 30th January 2026, the Commission opened infringement procedures against 21 member states for not fully communicating their transposition of this directive. So the national picture is genuinely uneven right now, which is exactly why agencies serving clients across the EU should check each target market.
And if a store owner wants to look up their exact legal rights, like the articles that lets them withhold refunds or penalize overused goods, what are the specific articles inside the Master EU Consumer Right Directive they should check?
Yeah, most of the articles are in the Consumer Rights Directive. As amended, Article 9, the 14-day withdrawal, Article 10, the extension if you fail to inform, Article 11, how to exercise, the new Article 11A, the button, and so on. So yeah, there are a lot of articles, but the main problem I see with, e-commerce, business people essentially reading the law directly is that it's not really written simplistically or easily to understand. It's really complicated. So I would suggest, even if you read it, of course, take a read. It's online, it's free, why not? But even when you're done reading it, I would still suggest consulting a professional in this field instead of just going off of what you read and what you interpreted that might be incorrect or inconsistent.
So, if a store owner wants to hire an expert to double check their layout, what specific branch of field of law does the that expert needs to be specialized in?
This is a really specific niche piece of law. Also, a specialist in EU consumer protection or e-commerce distance selling law, ideally with experience in the relevant national consumer laws and cross-border selling, plus data protection, as we said, GDPR, competence for the guest withdrawal data handling. This is very convenient for us because that's exactly what Chiroptera does. So if you're looking to amend your laws to get compliant, There will probably be a link somewhere, right, Jimmy?
Absolutely.
So they can
Absolutely.
contact us. So yeah, as I said at the beginning, we specialize with international trade, e-commerce, GDPR compliance, SaaS platform, marketplace compliance, which marketplaces have separate legal acts they need to comply with. So yeah.
So of course, I mean, I'm a web designer, web developer. Many of my contacts and the people watching my channel are also web developers. And for a business owner who realize that they aren't ready, what are the three first things they should tell their web developer to do right now?
Firstly, they should tell them to build a compliant login-free withdrawal flow that's prominently placed and available for the whole 14-day window.
Okay.
The first button, withdraw from contract here. The form must contain only 3 fields, so order number, name, and email. And the last step has to be confirm withdrawal button or something else that's unambiguous. Usually a footer link plus a dedicated page is the clear pattern. The second thing they should build is the auto-send system, which sends durable acknowledgement via the email they collected,
Okay.
ideally with a PDF that captures both the content and the exact date and time of the withdrawal. And thirdly, they should fix the surrounding compliance, because the button alone isn't enough. A correct withdrawal returns policy, the model cancellation form, clear pre-contractual information on the right and on who pays return shipping. And also they should map which products are exempt so the flow is applied to the right orders.
Well, I think we covered most of it, and it's been super interesting. I think this is a rule that has been going very under the radar because a lot of people, even today, are not aware that this is happening as of today. So I really appreciate your time, Robert. It was super great to connect with you and that you took the time to explain us and me and the community as well about what this rule is all about. And of course, I will put all your contacts in the description of that video. So if people want to contact you for any further information, then they'll be able to do it. Thank you so much, Robert. It was nice to have you online.
Yeah, thank you, Jimmy. I had a great time talking to you. Looking forward to future collaborations. And yeah, I hope we demystify this new legal concept coming to e-commerce. And yeah, good luck with the changes, the amendments. And if anyone needs any help, you can always book a 30-minute free consultation so we can discuss what your business is about, where we might collaborate, and what are the synergies. So yeah, thank you again for having us. And yeah, talk to you soon.
Thank you so much. I'll speak to you soon, Robert. Bye-bye.
Bye.
As usual, I hope this video was helpful. Thanks again, Robert, for taking the time to explain it properly to all of us. Thanks to Eduardo and Matteo for their help in the community. And of course, thanks to you for watching this video. And until the next one, stay sexy, keep spreading love, and I'll see you in the next one. Bye, guys.